Before joining the faculty, Professor Culbertson was a fellow at the Center for Study of Law and Culture at Columbia Law School and a lecturer at the political science at San Francisco State University at UC Berkeley. Professor Culbertson's research and writing presently focuses on counterterrorism, colorblindness, marriage, and the extraterritorial application of the U.S. Constitution. Professor Culbertson earned his A.B. degree from Princeton University, where he studied literature theory and theater, and a J.D. from UC Berkeley. His recent and forthcoming works appear in, among other places, Washington University Law Review, University of Miami Law Review, Stanford Journal of Civil Rights and Civil Liberties, the Journal of Animal Law, and Women's Studies Quarterly. Here at the College of Law, Professor Culbertson teaches Constitutional Law 1, 2, Foreign Relations, and Animal Law, and he was recently appointed to the AALS section on Animal Law. Please join me in welcoming both presenters, and I'd like to turn this over to John Marshall for the remainder and moderating the program.
I'd briefly like to thank everyone for coming on behalf of the Federalist Society. A quick word about Federalist Society. We are a nationally recognized organization promoting discussion and debate of constitutional issues and the separation of federal and state powers. It was founded in 1982 with the goal of discussion and debate. We believe that it is prominently the goal of the Constitution to say what the law is and not necessarily what the law should be, and that the Supreme Court and federal government should operate within the confines of the U.S. Constitution and separation of powers between states and federal government. After that, I would like to introduce our first speaker. Would you like to say a brief introduction? Either of you? Or we're going to go straight in? Straight in. Okay. Without further ado, please welcome Professor Tuan Samahon, Villanova professor, and all the president's czars. Thank you very much.
Thank you, John. I appreciate it. I appreciate the opportunity to be here in Syracuse. I'm a native of upstate New York from Rochester, and so this was nice to be able to head home. Today's comments are based on a paper that's forthcoming that's available on SSRN if you would care to read the full paper. It's entitled The Czar's Place in Presidential Administration and What the Accepting Clause Teaches Us About Delegation. And I want to begin with a bit of an introduction of how it was that I came to be involved in this particular topic, and that takes us back to October 2009, and these two met. And so here we have former Democratic Senator Russ Feingold, and then acerbic media commentator Glenn Beck, two men who don't seem to have, at first blush, much in common. And so my question is, what do these men have in common? And actually, they both shared a concern that the president was skirting congressional oversight through the use of czars on the part of back Republican conservative. The politics were certainly partisan. President Obama was occupying the White House. On the part of Russ Feingold, however, the story is a little bit more complicated. Russ Feingold, progressive Democrat from Wisconsin, is opposing a Democratic president on an issue of administration of his presidency. And I submit that his politics here were more institutional and constitutional. That is, he was defending the prerogative of the United States Senate as against the executive. Now, some of you may say, well, wait a second, I thought this was a Federalist Society event, not an ACS event. Why is the speaker beginning with some defense of Senator Russ Feingold? And it's going to be because I was actually Russ Feingold's witness, right? So, card-carrying member of the Federalist Society that I am, I was Russ Feingold's witness. As it turned out, the witness for the Republicans was also a card-carrying member of the Federalist Society, but John Harrison from University of Virginia. And on many of the Appointments Clause issues, we could indeed agree. And when we use the word czars, we should probably define what exactly it means. And first of all, this is a colloquial political label that is used, first of all, by administrations to bring prominence to certain issues and say, I'm taking this seriously, I'm assigning someone who is going to be dedicated to this particular issue. Right? So it's not any sort of term of art legally that you would find in the APA. Right? Instead, a czar describes a variety of positions that could present some constitutional problem or not at all. So let's talk maybe about what these positions are and which ones present absolutely no constitutional concern and that I want to bracket and put off the table. So first of all, a czar who is presidentially nominated and then confirmed with Senate advice and consent presents absolutely no problem. So this individual has been appointed in conformity with the Appointments Clause, and that should present no person, Federalist or ACS, any problem. Let's lay those people aside. The second set of individuals who need cause no concern are those czars who we say are officers, but are said to be inferior officers, whose appointments are vested in another branch of government, that is, Congress has elected to opt out of the process of nomination and confirmation with Senate advice and consent. That's permitted by the Constitution, the accepting provision of the Appointments Clause. You'll recall that this was at stake in the Morrison versus Olson case. I believe personally the majority had the analysis of what it meant to be an inferior officer incorrect, but nonetheless that is the provision of the Constitution we're talking about. So, example, Congress has opted out bankruptcy judges of the process of advice and consent. They are not appointed by the President. The Senate does not give its advice and consent. Their appointments are vested in the courts of appeals. All right, so pursuant to that statute, the courts of appeals around the country appoint the bankruptcy judges. To the extent that these bankruptcy judges may really be said to be inferior officers, that presents no constitutional problem. Now, bracket query whether they really are inferior officers. I've written on that subject and questioned whether that's indeed the case, and you can read that article in the Hastings Law Journal. I'm just going to leave that platform be for now because I like to move the podium a bit much. So let's move on then with the third category of czars, and these are the czars that truly present the problem. And these are individuals who are said to not be officers of the United States, but merely employees. These are individuals said to be merely advisory, that is, purely advisory individuals. The congressional anxiety begins when these individuals displace Senate advice and consent confirmed officers in the exercise of their responsibilities. So let's talk about the czar anxiety. Here we have Anthony Van Jones, who was to be green job czar. There was a political kerfuffle. He ends up not exercising office. This is my former evidence professor, Ken Feinberg, who's been a special master in all sorts of things and has served as the TARP pay czar. He's an inferior officer, arguably, though Mike McConnell has opined that that is not properly opted out of advice and consent. And the gravamen of the Senate's concern is this, is we have no say in the selection of these individuals. So these individuals are selected outside the purview of Senate advice and consent. We don't have any say on the front end in their selection. And so that means that the President could choose ideological outliers, whether that's a Republican President or a Democratic President, outside of any sort of front-end control of the Senate. And on the back end, the Senate is concerned that there is inadequate ongoing supervision and monitoring and ability to bring these individuals into the Congress to speak with them. Now, why is that? Because these individuals, depending where in the White House they may be located, may be immune to, for example, their documents immune to Freedom of Information Act requests. And also, the President can assert executive privilege on their behalf, thereby shielding them from appearing before the Congress. And given that they are not officers of the United States, neither are they subject to the impeachment clauses of the Constitution, because that reaches only officers. And so Congress is concerned about this democratic deficit in governance, that is, individuals selected outside the process and not monitored adequately by the Congress. And so let's talk about the Appointments Clause here briefly, because I want to set up for you the explanation that the White House gives about why its czars present no problem. And so first of all, if you're unfamiliar, is Article 2, Section 2, Clause 2, the Appointments Clause. And again, the President shall nominate and bind with the advice and consent of the Senate, shall appoint ambassadors, other public ministers, consuls, judges of the Supreme Court, so certainly the enumerated officers must be appointed, and all other officers of the United States. And here's this language I was telling you about earlier, the accepting provision, but the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or the heads of departments, right? And so the idea is that this opt-out provision can allow Congress some flexibility with regard to the inferior officers by giving the appointments power away. And you can conceive of this as the only instance in the Constitution where delegation is actually authorized. So namely, Congress is authorized here to give away its power over appointments with regard to inferior officers. And it uses the language of vesting, which is the language of delegation. There are only 5 instances in the Constitution. If you use the Constitution as its own dictionary and you compare it intertextually, the 3 first instances are the vesting clauses of Articles 1, 2, and 3, which delegate from the people the power that is legislative, executive, and judicial, and vest it in the trinity of powers that are the 3 branches. Then in the necessary and proper clause, where it refers to Congress having the power to implement those powers that have been vested, so it's a reference again to the vesting clauses. And then the 5th and final occurrence is here, where Congress can vest the authority to appoint, it's a very cabinet authority, to appoint and only inferior officers. And interestingly, and we'll return to this later on, it specifies who the recipients are. So constitutionally specifies and reinforces congressional enactment saying that the power goes to certain persons and certain persons only. So the President alone, the head of departments, and the courts of law. So let's run through some czars here. Let's talk about them for a moment. Who are some czars? We've got, these are not currently serving, Herb, Allison, Ed Montgomery. We've talked about the fact that they can be officers, that this doesn't present a concern, that is, so long as they're appointed with advice and consent. What does it mean to be an officer? It means that you exercise Senate advice and consent. That means that, you exercise significant authority in the United States. You may have been appointed with Senate advice and consent. Now, forgive me if I'm wrong, I just want to pause, John. You said I had 5 minutes. I thought we had 30 minutes. Is that wrong?
This is a 15.
Oh, okay. All right. So we're going to pick up the pace here real quickly.
Okay. He's okay with you going longer.
Okay.
I am too.
Okay. So the officers have to exercise significant authority of the United States. We talked about this opt-out clause. Who is an officer for the meaning of the Appointments Clause? How do we know if someone counts as an officer and must be appointed pursuant to the Appointments Clause, or someone who's merely an employee? And according to OLC, the Office of Legal Counsel says to be an officer of the United States, you have to hold a position which is, as it says, delegated by legal authority, so statutory authority or authority implementing statutory authority, a portion of the sovereign powers of the United States government, and that is continuing. So in other words, you have to have the power to make decisions that bind the United States government and be in a continuing position. If that defines your job, that you have the power to decide and bind the sovereign, then you become an officer of the United States. And OLC has a few other exceptions, caveats. This is a 2007 OLC memo. So let's talk about the non-officer czar. So I wanted to put up Condoleezza Rice for a couple reasons. Well, she had two different positions within the Bush administration, right? One of which was a czar position. The other was an officer of the United States. So in the first position, as National Security Advisor, she was a mere employee, right? So a mere employee, technically not an officer, just statutorily commissioned officer, but not an officer in the constitutional sense. She lacked legal authority to bind the sovereign, but she had considerable clout. She manages a staff of over 100 national security specialists, but she's said to be purely advisory, right? So the idea is she is a national security advisor, assistant to the president for national security affairs. And so this is a distinction. So an employee that is said to be purely advisory, a czar, you have political clout. You've got the ear of the president. You can speak to the president, you can persuade the president, but that's not final decision-making authority. The decision resides in the president. And so this makes her purely advisory, outside the scope of the Appointments Clause. So let's run through some of the bill of particulars about the Senate complaint. And I want to, for a moment, talk about something that Russ Feingold didn't ask me to talk about. He asked me about the Appointments Clause issue, and my testimony was the following, that the Obama administration is correct that in as much as someone is truly, purely advisory, they need not be appointed under the Appointments Clause, that's perfectly constitutional, but that to the extent that they are exercising decision-making authority that binds the sovereignty of the United States, that means that the president is skirting the Appointments Clause. And the concern, again, is what if we had someone like a climate czar within the White House who is able to preempt an administrative agency's work. So let's say the EPA spends an awful lot of time crafting certain regulations to regulate, for example, ozone, and that these regulations then are killed by the White House in a process through which the president's czars exercise very significant authority, ostensibly at the president's direction. Right? And so the question is, does this present a constitutional concern? So the question I was not asked by Russ Feingold that I did want to address today, having set up this problem, is whose fault is this situation? That is, who is to blame? And surprisingly, I want to lay the blame, and perhaps this is why Russ Feingold didn't ask me, I want to lay the blame with Congress. Why do I want to lay the blame with Congress rather than the President? And in order to do so, I want to make quick reference, shorthandedly, to a spatial metaphor to explain how it is the czar comes to have her power. And I'm going to describe it in the following way, which is going to be over, up, down, around. And so let me walk through this very quickly for you. So over. For those who have Constitutional Law 1, you may have heard of the delegation doctrine. This allows Congress, notwithstanding the clear terms of Article 1, Clause 1, that all legislative powers herein granted shall be vested in the Congress, it allows Congress to make certain high-level policy decisions, very high-level policy decisions, and pursuant to an intelligible principle, so regulate the air for the public's benefit, health, safety, etc., to delegate the particulars of that very broadly articulated policy to the agency, right? And so Congress often, when it legislates, will, as a condition for this delegation, wants to specify who gets that authority statutorily. So they say, for example, I'm giving this statutory authority to a Secretary of Energy, for example, or the administrator of the EPA by statute, right? So that's the first move, and this is the horizontal movement of power, if you will. You can imagine Article 1 and Article 2. It's the passing of power from the legislature to the executive. And again, the fiction we entertain here is on the formalistic account that Congress has made its policy judgment, and so therefore it's not really delegating power. It's just allowing the executive lots of discretion with the implementation of policy. So that's over. So up, and this next step up is a development we have seen in recent years, and the intellectual justification lies with Associate Justice Elena Kagan, when Dean of the Harvard Law School, and I may have this chronology wrong, she may have been actually at Chicago at this time. She wrote a famous article published in the 2001 Harvard Law Review entitled Presidential Administration. And much like defenders of executive power from the Bush administration, she favored a very strong executive. And she says that notwithstanding the fact that Congress has, by its statutes, named certain offices to be the recipients of power, that the president should be able to exercise those powers himself. That is, in other words, engage in certain canons of statutory construction for pragmatic reasons, namely that the president has a national constituency, that the president has energy and vigor, and that these agencies can be very slow to move and bureaucratic, and so we want a strong president who can kick these agencies into gear. And moreover, Elena Kagan says, for critics on the left, she was in the White House under Clinton, who think that presidential administration can only be used in a deregulatory fashion, she offers some examples of how it can be used in a pro-regulatory fashion. And so this is the movement up, that the president, notwithstanding statutes that give the authority to officers located within agencies, who, by the way, are subject to Senate advice and consent, and who are subject to FOIA, who are subject to all the other procedures that attach under the APA or the Organic Act of the administrative agency, this is the relatively procedure-free exercise of discretion within the White House. So the president asserts, I am able to exercise this power. And so this is the movement of power upward from the agency, centralized into the White House. So the next move is the president now having claimed this authority. And I want to be clear here that there are members of the Bush administration who would view this definitively as a feature rather than a flaw. Their justifications are going to be formal rather than pragmatic. But I want to talk about Kagan's paper here for a moment. So the next step is, now that I've got all this authority, what am I going to do with it? I'm busy. I'm the President of the United States. I'm the head of state and I'm the head of government. If a foreign dignitary dies, I must be there. The opportunity cost is tremendous. I have a 4 million person federal government to run. The functions of government are enormous. And so for the very reason that we have agencies, the president finds himself needing to delegate. And so here we have down, is that the president redelegates this power. And he redelegates this power pursuant to what I term as a vertical intelligible principle. That is to chosen individuals that he has picked, the czars, right? So these are individuals who are not necessarily, and I would generally say not Senate-confirmed officers. And why does he do that? Well, because he prefers their policy preferences, right? They're not subject to the sort of silent operation of Senate advice and consent that forces a president to moderate his or her picks from ideological ideal points. And so the president is better able to pick these individuals. And so as part of this paper, and this is the part of the paper I'm most proud about, I did a lot of Freedom of Information Act work, struggling with OLC to wrest loose some of their memos from over time, developing the doctrine of subdelegation of presidential powers. And I'm happy to say that I was able to prevail in some administrative appeals against OLC, and I did get loose some of these documents. And one of your faculty members has recently written about one of these episodes. Professor Turnipseed, is he here today? Professor Turnipseed recently wrote about Attorney General Assistant Attorney General William H. Rehnquist's advice in the Office of Legal Counsel. This is one of the memos that I was able to wrest loose. And so the story is that over time, that OLC has increasingly, with greater permissiveness, allowed the president to delegate power to who he wants. And this is interesting because there is a statute that regulates a president, or purports to regulate to whom he may delegate. It's called the Subdelegation Act of 1950 by commentators. And it says that you can delegate, but you can delegate only to individuals who are Senate advice consent confirmed, subject to some other caveats that I won't elaborate at this point in time. And so the story is concern initially on the part of OLC about these individuals getting power, czars, and then later on embracing the idea. So to illustrate, 1969, Assistant Attorney General William H. Rehnquist gets a request from John Ehrlichman of Watergate fame or infamy, who was counsel to President Nixon and assistant to the President for Domestic Affairs. And Ehrlichman sought, quote, delegation of authority to members of White House staff to physically sign documents. Now, Rehnquist here was very politically astute and was very concerned about what would happen. Namely, if a document comes out of the White House purporting to have been signed by the President that is making some sort of decision, it would be very difficult for one to know what actually happened within the black box if we allow the President to delegate his authority to physically sign documents. And so, perhaps concerned that the apprentice may seize the sorcerer's wand, Rehnquist cautions Ehrlichman. He says, it would not be proper for the President to delegate decision-making authority to members of the White House staff. In other words, binding authority to bind the sovereignty. That would not be appropriate to delegate to staff. And by staff, we mean positions that are not legal positions, officers of the United States. So your office, rather than ours, has the information to decide whether the delegation of only the act of signing of particular types of documents would materially reduce the administrative burdens on the President, where he retains the decision-making function involved. And so that decision-making function needs to reside in the President. And so Rehnquist senses the danger here and wants to give the advice, yes, you can delegate just the act of affixing a signature, but no, nothing more. So the Carter administration. So Carter administration, not usually thought as being very strong on executive power. The Carter administration has an initial flirtation with a subdelegation. It's cautious at first, but then it later embraces it. Under the Subdelegation Act, remember, only officers of the United States who are confirmed by the Senate can receive delegated power. But here, the President Carter, wanted to delegate to Walter Mondale, Vice President. But the Vice President is not confirmed with Senate advice and consent. And so he could not be an appropriate delegate. And so what was the choice that was made? Well, to claim an inherent power to delegate. So that is outside of this statutory scheme. Well, this is embraced by the Reagan administration wholeheartedly, which is all on board with inherent claims of executive power. And then we get up to the Bush administration. In 2002, we have John Yoo. And so John Yoo, Deputy Assistant Attorney General, post 9/11, wants to consolidate and centralize border control at a time that is pre-Department of Homeland Security. So it's not been statutorily authorized. The President had a proposal. He said, how about you designate one person and make this one person able to remove others? And so that way, he can enforce his will and be an effective coordinator. So he can say to then INS, Immigration Naturalization Service within DOJ, you know, you're going to do this. He can say to the Coast Guard, you're going to do this. We're going to work together to try and solve the nation's immigration problems. So John Yoo says that that's not permissible, right? So the President, generally speaking, can't delegate constitutional powers. But John says, I have a workaround. And so here's the workaround. So John says, this, you know, he wants to sort of respect the formal requirement of non-delegation, but by taking, I think, I disagree with Professor Yoo here, with the facts on the ground. And so he puts it this way, we're going to name someone who's going to carry no legal authority. So in other words, they're purely advisory, they can't bind the United States. These persons in practice are advisors. They're advisors to the president. But what we're going to do is we're going to make some manifestations that make them look like more than an advisor. So namely, we're going to formally and publicly designate these individuals as the point person on the particular issue. And then moreover, we're going to formalize the informal arrangement by having an executive order specifying it. And so what you hope to do is to have his cake and eat it too, so that is effective and functional control by a czar, and at the same time avoiding an actual delegation. So my concern, of course, is that this amounts to sort of an apparent authority on the part of the czar. So that then is the down part, right? So we've done now over, up, down. And so now the around bit, right? So what's the around? Is we need to get around the appointments clause. So how do we get around the appointments clause? And that is we have to entertain this fiction that these individuals truly are only advisory and they're not final. And so to think about this, I want to go back to this idea of a vertical intelligible principle. So namely the president delegating down to a czar some high-level set of standards of objectives to attain. So consider the following example. Condoleezza Rice calls in the middle of the night and says, President Bush, there's been a revolution in Kyrgyzstan. I recommend the following, these are broad objectives with details to be filled in further. The president says, make it so. And so then Condoleezza Rice goes off and she coordinates with the Joint Chiefs, the Department of Defense, National Security teams, so NSA, CIA, everyone else. And so here she acts making decisions on behalf of the president, apparently with the imprimatur of the president, who is signed off really only on a high-level, broad, general authority of delegation to her. Right? And so this is the fiction of purely advisory. The idea that these individuals, outside of Senate advice and consent, don't actually exercise power, but merely are politically influential individuals. Okay, so final comment, and I'm about done, right? So the final comment is that there is something for us to learn from the accepting clause of the Constitution with regard to delegation. So generally speaking in our Constitution, there is no textual justification, I should say no textual support for the idea of a generally delegable power on the part of Congress to delegate rulemaking authority. That justification is mostly pragmatic rationales. It is not rooted in text. But the framers in the accepting clause show interesting insight in their drafting of that level, the drafting of the accepting clause. And it's for this reason. So first of all, the power is carefully cabineted. So remember that the only power that they can delegate is the power to appoint an inferior officer, right? So it's not high-level, broad, intelligible principles. Second, they recognize that the act of delegation is a vector. That is, that it can be decomposed into a horizontal and a vertical component. That if I delegate authority, there is a difference between it going to the president alone and the head of an executive department. Okay. Possible remedies. So I'm going to leave this for possible rebuttal because I'm suggesting that there may be a good one forthcoming from Professor Tucker Culbertson. So let me, with that, yield time to him. So and just say then, so if this is indeed a problem, Samahon, what do we do next, right? And so I'll leave that for my SIR report. Thank you.
Okay. I appreciated very much the term Professor Samahon used, czar anxiety. I do think that there has been long-standing anxiety about such individuals, I think it has seemed to be more energetic lately. It has occasioned more sustained conversation. And as an opening question, I wonder how exactly that's related to the present administration, how that's exactly related to the conduct of President Obama, in terms of perhaps an increased use of czars, both in their hiring or in their authority, or if we might understand the sort of coalition of, again, diverse opposition and concern to have something more to do with a certain amount of disfavor for President Obama's particular interests. That being said, the problem, if it is a problem, of positions of the czar, it seems to me is one, and certainly not the worst, symptom of the standing practice of the legislature's delegation of legislative power to administrative agencies and other configurations within the executive branch. And so I want to suggest that while I certainly appreciate that Professor Samahon has chosen not to sort of call for the death of the administrative state, which is simply unimaginable at the moment, but great change often is unimaginable. That's a joke. So I do want to say that while I respect that approach, I think that the state of delegation by the federal Congress is far too grave and far too serious for us to approach it incrementally. So, as has been suggested, right, this anxiety about the czar is connected to a question about, well, a desire for congressional oversight of policymaking in the executive branch. That seems delusional to me. It seems delusional to me that the federal legislature, who has not only the power but the duty to maintain social policy and to pass legislation, should have to be sort of fighting for oversight of such policy. So I want to suggest that the non-delegation doctrine, or now the delegation doctrine, which has as a principle that there should be rules governing circumstances where branches of the government cede some part of their power to other branches of the government. And as Professor Samahon has said, there are a series of rules, most clearly perhaps established in the Yakas case, for how and when such delegations may occur. I am not comfortable in any way with that convention and that practice. And let me explain why. How should I do this? Well, okay, let's say this. You're all going to die, right? You are. And hopefully, when you do, you will have a will. And hopefully, that will have a competent executor who will ensure that the terms of your will are in fact executed. I think you would be gravely saddened and surprised to learn that the executor had instead drafted the will upon your death based on intelligible principles of your interest. My understanding of the executive is that the position is to execute, not create, the law. And so the slow but then exponential increase in delegation, which has led to a massive executive branch where some of the most important social policy issues of our time are being decided by, again, unelected individuals, appointed, confirmed, whatever, is staggering to me. Not only because it seems somehow constitutionally improper. I mean, although I can get, sort of worked up about separation of powers, I have a separate concern, which is that this practice has, in my opinion, rendered the Congress both unwilling and frankly generally incapable of performing their duty to legislate. In watching the recent debates on debt refinancing, but also long before the financial collapse of 2008, it was painfully clear that many of those tasked with addressing this problem were not capable of doing so. the general deference that we see Congress cede to the executive in the context of certain foreign affairs matters, the general deference that we see in matters of finance, right? I mean, the Federal Reserve and the constitutionality of it, I'll say for another day. But the fact that our financial policy through the Federal Reserve and the Department of Treasury is largely being dictated by the emeritus bench of Goldman Sachs is deeply troubling to me. So my point is to say that the general convention and the accepted logic of horizontal delegation, even subject to senatorial approval of particular appointees, appointed by whom? Usually the president anyway, is severe, is damaging, and I think is a quite serious problem of which the Czar issue is one component, but I think that it is a very minor component given the state of administrative rulemaking, executive lawmaking, and legislative abdication. Again, I want to stress that I understand constitutional powers to be duties, and I find present practices deeply disturbing. Well, what does that mean? Perversely, it means that I think the czars are, in fact, our best bet for sound policy making under this deeply tainted and troubling state of affairs where we have four, if you will, branches and an executive who understands himself to be lawmaker. Now, how is that possible that I would say I think the czars are our best bet? Well, we have, over a long number of years, established the situation which I've described that begins with congressional abdication of its responsibility to become expert in and legislate on the most pressing matters of social concern. Given that that is the state of affairs in which we presently exist, given that we have a deeply empowered unilateral executive who is in the business of policy making and whom we expect to make policy, right? How often do we look for the president to tell us what we're supposed to do about health care, to tell us what we're supposed to do about finances? What is the president's policy position? I'm not sure I care if he has one, right? But given that that is the state of affairs in which we are existing, I think we have to, unless we are going to challenge its basic principles, I think that we have to act in a way that best reflects and allows for the best possible version of this present state of affairs. And I think that given the abdication and its consequences, allowing for expert appointees who are not subjected at all to congressional approval, oversight, and the wrangling that goes on therein is the most appropriate method of appointment and of policy making within the state of affairs where our president seems to see himself fit and our populace seems to demand that he define and dictate policy. So in the state of affairs where Congress has in many ways been reduced to the position of counterpunching at best, it seems to me that the czars are very well suited and in fact necessary for that arrangement. So, would I ideally like to start talking about sort of more radical responses? Absolutely. Until then, I think we are obliged to support and continue with the manner of appointments and of policy making that best suit this undesirable system. Thank you. Sure.
I appreciate Professor Culbertson's remarks, and I want to second the concern about legislative delegation and that the abdication of legislative duty that indicates. Public choice theory gives us one set of explanations about why it is that legislators buck pass and delegate to the so-called independent agencies and the executive branch, and part of the explanation is to evade their duties in the face of forceful pressure from interest groups. I want to talk about one legislative remedy that has been proposed and is on the table that might put the ball back in Congress's court and could be salubrious in addressing the czar difficulty or concern with czars, and that's some legislation called the REINS Act. So the acronym being this idea that the executive needs to be reined in, and the acronym is Regulations from the Executive in Need of Scrutiny. And so this legislation says, gee, we're really concerned about administrative agencies and the power that they exercise. For example, the concerns are legion. It could involve agency capture by particular industry groups. It could involve agencies making politically sensitive choices without democratic input. And so the REINS Act says, roughly, that major agency rules that are emerging from a rulemaking process from an agency, prior to these rules taking effect, that Congress must act legislatively to approve these rules. So now these may be rules that emerge from an agency process and then have subsequently been altered, adjusted, tampered with, depending on your viewpoint, by czars, right? And so the proposal under the REINS Act is, well, one way to fix the problem is for us to own it. That is, to own the regulations that come out of these agencies. And that is for bicameralism and presentment. So just like any other piece of statute that would be codified in the U.S. Code, these regulations emerging from a rulemaking process would be subject to bicameralism and presentment. And so giving Congress the opportunity to legitimate, because curing the democratic deficit problem that would exist with a czar, and owning the regulation. Now, this was a proposal by none other than Professor Stephen Breyer from Harvard Law School, who I believe is in a position now to maybe help influence public opinion on this particular matter. But this would be a proposal that maybe is radical, but would have the salubrious effect of being democracy reinforcing and could help address the czar problem. I'll note one other approach that Congress has taken, and it was actually one that I proposed in my testimony, was that Congress also has the power to budgetarily cut the pay of czars it doesn't like. You don't like a czar who's in the White House, you could always cut his pay. I mean, I could certainly call Tucker, if I'm President of the United States, and solicit his advice from the Syracuse University campus, but his proximity and pay in the White House makes him much more powerful, right? Proximity is power. And so Congress could always remove these individuals by just cutting their pay. Instead, Congress has given a blank check statutorily authorizing a sizable budget for these advisors. So Congress, sort of heeding the advice that I and others had offered, decided that it would cut 4 positions. But to prove that Congress sometimes lacks the will and spine to do what's necessary, it engaged only in chest thumping and in faint-hearted budgetary checking when it cut 4 czar positions that were unoccupied by any czar. So in other words, it didn't want to provoke a controversy with the president. It picked certain individual czar positions that were vacant. And the president, in response, had a presidential signing statement in which he scolded the Congress and suggested that its budgetary stripping was unconstitutional, but we're not exactly clear why it's unconstitutional, because plainly it's silly to say that Congress must fund any type of particular position or advisor as a matter of constitutional dictate. So with that having been said, I guess, do we have time to open to questions, comments, criticisms from other faculty or students?
I would open the floor to questions. If anybody has one, I would certainly...
And can I invite Professor Culbertson up too to take a bullet with me?
I would start off by... Oh, I don't think we have a secondary one. If we do, we can be out of here.
Can we thank Professor Culbertson? He's
Yes.
very generous.
Yes, sir.
comment.
Thank you
very
both
much.
for
I was very happy to delegate that.
Mr. Culbertson, your comments reminded me of Youngstown, in that never waste a good crisis to overuse presidential authority to exercise some presidential discretion. So, would either of you care to respond to that, and then I will defer if the audience has any questions also.
Well, on some level, there are principles in Youngstown that are being espoused about unilateral executive power that are worth considering. What's the difference being sort of the context of action in time of war and the seizing of domestic property, which we have a long tradition against. So I think, again, I do think that discussing questions of unilateral executive power, whether it's counterterrorism under George W. Bush, or whether it's, finance management under President Obama, is necessary. And so, yes, I think the issues in Youngstown are very helpful, even if they're not doctrinally direct. And I do think there is a class weighting, so we should give them. We can take another question, I think.
I think a lot of the discussion today, and obviously, this is a constitutional discussion, but, is the real issue, rather whether the executive has the powers to do this or whether they're, usurping congressional power. When it boils down to it, is the reason that we need the czars and the reason that the Congress can't act really that the federal government has usurped so much power from the states and sort of made an end run around the 10th Amendment that at this point the federal government's to the point where it's no longer manageable in its current form. Is that the real problem? And should we be sort of taking the federal government out of some of these smaller administrative agencies? Because it seems like these days we have an administrative agency for everything.
I mean, I'll offer one response, which is to say, I don't think we have to say that it's really about the federal-state relationship and not, but I think it certainly has to be factored in. And then when it is factored in, right, what we'll have to deal with is that the dynamics Professor Samahon has discussed are certainly happening at the state level too, right? So the questions about accountability in policymaking are certainly going to show up at the level of state executives and agencies. But yes, I think the question of state-federal power sharing and the domains of appropriate federal legislation and regulation are certainly part of the conversation.
And let me give you my response, and that would be that absolutely, I think you're correct in that a Commerce Clause on steroids gives the national government vast swaths of power, but it also centralizes regulation in a way that raises the stakes significantly, as opposed to the diversification of regulation among the several states, which is not to say that the phenomenon doesn't also occur at the states. It's just that it does raise the cost for example, regulated industries to capture particular agencies, right? So one could take a pro-consumer, anti-federal regulatory approach and say that that national businesses prefer national regulation and that they actually lobby for national regulation in order to preempt state regulation, which may be more stringent than that national regulation, right? And so one can be pro-consumer and anti-federal regulation, and again, to the extent that we raise the stakes of national, federal regulation, I think we make the problem all the worse. Right?
Thank you again, everyone. I'm sorry.